First of all, many thanks for your participation to this 2025 KLS Summer of Law webinar series. This is the 6th year that we are running this series of webinars, and if you can give a look at the program, you might see that it looks fantastic. Now, today, the topic of today's event is emergency laws, and the speakers, as you can see on the screen, will be myself. I'm Dr. Giacomo Fusco, and Dr. Tom Frost, and we will present in both general terms what emergency laws are and why emergency laws are relevant as a legal topic, and also why emergency laws are relevant to understand, to have a critical reading of why emergency laws are relevant in the current global scenario, for instance. And we will present, we will deliver 2 presentations, and I will go first. And the topic of my presentation will be very generally about emergency laws, and I will get into also a specific scenario. I will look more specifically at the implementation of emergency laws during the COVID pandemic in the United Kingdom, and more specifically at the imposition of the lockdown, the first lockdown in 2020. While instead my colleague and Tom Frost will look at how the state of emergency laws were used more politically in the context of Kenya. So let me share the screen. Okay. So I guess the slides are on and I can start. So emergency laws. So what are emergency laws? As you can see on this slide, emergency laws are special legal provisions, are actual laws, which are usually enacted for a limited period of time, and which allows governments to activate and to act often against the normal, against the legal system itself. So emergency laws allows government to act extra legally, so against what it is normally, against the rights that are normally protected by the law in normal time. And of course, the justification, it is the justification of this possibility of acting against normal laws is the fact that there is an emergency. So as you can see, these emergency laws are usually activated during extraordinary situations, such as, of course, war, armed conflicts, civil unrest, and of course, widespread social violence, disasters, of course, natural or human-induced, public health crisis, we remember the COVID pandemic, and also economic emergencies. Now, these laws usually grant the executive branch, the president, prime minister, etc., to expand powers to respond quickly and decisively to a given situation of crisis. However, they often limit or suspend normal legal protections or rights in the process, and we will see what does it mean concretely. Now, the justification for the very existence and the use of emergency laws is quite interesting from the point of view of legal theory and also legal practice. So it is the perception that normal laws, that the law works effectively only in normal time. So when there is when social relationship and the political situation in a community, in a state is normal and does not present crisis or emergencies. And of course, this is, in a sense, controversial in itself, because one could ask, why do we need emergency laws? Isn't the law a perfect instrument to regulate both normal times and emergency situations? Well, I mean, if we look at how, for instance, the law are produced in parliament, we see that the legislative process is very long at times. It takes at times years to pass a law. And of course, in a situation of emergency, when timing and timeliness is paramount, is very important. The legislative procedure, prolonged legislative procedure, could be counterproductive and could also be harmful for the very self-standing of the political of the political community and society at large. Now, traditionally, emergency laws allows for the suspension of liberties, such as freedom of movement, assembly of speech, and we have seen this very clearly during the COVID pandemic, when we have been when our freedom to get out from our house and also to enjoy the company of our friends and family has been curtailed and limited. But emergency laws allows also for censorship and extensive media control of media and communication, and this is typical of wartime, and is something that, you know, heavy censorship of media and control of communication is something that luckily in Europe we are not witnessing since I would say decades. But if you consider, for instance, what's going on right now in Ukraine, in wartime, the control of media is very important to keep control of society and also to protect society from the spread of false information and news. Of course, emergency laws allows the government to impose curfews and lockdowns. Again, we have experienced this quite recently. Emergency laws allows also for grants often the police of special powers, especially in regards to detention without a trial and interception of private communication. And of course, in the most extremes of the cases, in cases of insurrections and revolts, emergency laws allows also for the government to make use of military force domestic. Now, which are the sources of emergency law? So where we can find, you know, in a written form, emergency laws. Of course, countries with a written constitution usually, I would say normally, includes provisions regulating the use and the implementation, but also the legislative process to create emergency laws. And here I just mentioned two examples. One is Article 352 of the Indian Constitution and Article 77 of the Italian Constitution. Of course, statutes. The United Kingdom, we have the Civil Contingencies Act, 2004. But also the regulation of emergency laws is part of also international treaties, and there is the famous Article 15 of the European Convention on Human Rights, which is quite interesting because it's on the one hand it grants a sort of margin of appreciation to countries to regulate their own implementation and emergency laws in general, but at the same time gives a strict definition of what an emergency is. An emergency is what is a threat to the life of a nation. And it's quite interesting to see also how emergency laws have been shaped in the relationship between domestic law and international law level. And of course, this is relevant for liberal democracies, but also democracies in general. Emergency laws, like many laws, are subject to judicial or legislative review. But if you look at the history from the historical point of view, the judiciary has always been, I would say, not very tough in reviewing the action of the governments in cases of in period of emergency. Now, but why are emergency laws a problem for the law itself, but especially for the law in democratic regimes, especially in liberal democracies? And this is a citation taken from an important book on the topic. And this is how the two authors, Oren Gross and Funalani Olain, are explaining this apparent paradox, not even apparent, I mean, it's an actual paradox. And they claim that the existence of restrictions and limitations on governmental power is a fundamental attribute of democratic regimes. The ideals of democracy, individual rights, legitimacy, accountability, and the rule of law suggest that even in times of acute danger, government is limited both formally and substantively in the range of activities that it may pursue and powers that it may exercise to protect the state. However, grave, violent emergencies challenge this organizing principle. The question then arises as to what extent, if any, violations of fundamental democratic values can be justified in the name of the survival of the democratic constitutional order itself, and if they can be justified, to what extent a democratic constitutional government can defend the state without transforming itself into an authoritarian regime. Now, this is the main issue with emergency laws. Emergency laws are very useful instruments, but if you look to the history, especially of the last century, of the 20th century, the use of emergency laws as often it has. I mean, emergency laws have been used to create a change in the democratic regime towards an authoritarian regime. I mean, the most meaningful example is Hitler taking power in Germany. Technically, when Hitler got into power, he has been elected as the chancellor in the Weimar Republic, and he has been able to impose a dictatorship and his own version of an authoritarian regime through law by making use of emergency laws. So he declared the state of emergency at the very beginning in 1933 with the Reichstag fire decree, which is a declaration of emergency. And from that moment on until the end of the war, when he died, when Germany has been occupied and sectioned in 4 parts, until that time, the Nazi dictatorship has been under a state of emergency for the whole 12 years, and this is quite problematic, both in legal terms and in political terms. So, on the one hand, emergency powers, emergency laws are useful to protect society and to protect the state in a case of emergencies, but are very powerful instruments that can be misused by governments and can be used to transform a democracy into a dictatorship. And of course, these are this is a short list of the risks and criticisms of of emergency laws. Of course, abuse of emergency powers, wide infringement of liberties, and leaders may use emergency laws to silence opposition or cling to power, or, as I mentioned in the case of the German Nazi dictatorship, even to change the democratic system itself into an actual democracy and to perpetrate all the crimes that the Nazi regime committed. But there are also more subtle risks involved in the very existence of emergency laws, and is the long-lasting alteration of constitutional settlements and a slow erosion of democracy through the prolonged or repeated use. The prolonged and repeated use of emergency laws can weaken democratic institutions. This is also known as normalization of the exception, normalization of emergency law, so a normal use of emergency laws. And we have seen this, and one recent example is the 2015. You might remember that in 2015 in France there were a series of terrorist attacks. And the government implemented emergency laws, and these emergency provisions, these emergency laws, the government made use of these emergency laws for more than 2 years. And then all the emergency laws that have been created, starting from that original crisis, have been enshrined into normal law in 2017. So what does it mean? It means that the police in that period in 2015 have been granted temporarily through emergency laws specific powers, and these powers after 2 years have been made normal, have been transformed into normal law. And this is what we call normalization of the exception. Of course, there is a big difference between this more subtle a normalization of the exception, so the transformation of specific provisions, specific laws that were meant to be temporary and limited in time into a normal law. Of course, this is something, this is a slight change compared to the misuse of emergency laws, for instance, made by Hitler in 1933. Okay, so we could say that if Hitler has been able to change as a sort of a legal coup d'etat the democratic asset of Germany of that time in very few months, the normalization of exception is a similar thing, but in a more subtle way. We could say that with the normalization of the exception, the democratic regime does not change, but the law includes some element of emergency laws, and we could say that the government becomes stronger compared, for instance, to the legislative, and the police acquire powers that normally would not possess. Again, this is taken from an interesting, important article by Fairjohn and Pasquino, The Law of the Exception, a Typology of Emergency Powers. And they claim that there are at least 2 characteristic features of the problem of emergencies in modern time. First, as mentioned above, contemporary emergencies cannot easily be limited in time or space, and this raises the specter of needing a permanent emergency regime. Second, it is no longer clear prior to an emergency what powers are needed to cope with it. And this is because we have seen, especially in the, we can place, for instance, the question of emergency laws also in the context of global warming. And we see that natural disasters are become normalized. And if a reaction have become, natural disaster have become part of our daily life, and if emergency laws are usually used to cope with disasters, and disasters become part of our daily life, even emergency laws become part of our daily life. So we abandoned legal normality to enter into a sort of a new legal normality, which is not normal anymore. So you see that these are all paradox. These are all contradictions that are embedded in the very use and existence of emergency laws. Now, I would like to talk now about an actual scenario and some of the legal issues that have been part of our recent history, especially I'm referring, of course, to the COVID pandemic. And I've used, I want to talk to you about the actual implementation of the first lockdown in the United Kingdom on the 23rd of March of 2020. This is quite, this example is interesting because it's, it gives us, in a sense, a practical example of the problems and of the legal issues involved into the administration and implementation of emergency laws. Now, the 23rd on March 23rd, 2020, the UK Prime Minister Boris Johnson declared the national lockdown. Household mixing and gathering were forbidden, confining millions of people at home, except for going out to buy essentials and for one exercise a day. The police were given the power to enforce the measures. The effect of Boris Johnson's televised statement was immediate, but legally uncertain. The law, which was to back up his unprecedented instructions, did not formally exist. Police authority to enforce the lockdown did not have a clear legal base at the very moment. So what does it mean? It means that at that time, of course, it was a matter of urgency because we, in Europe, there were already other countries that have imposed a lockdown, and we know that a lockdown is a huge infringement of our liberties, especially of movement, but not only of movement. So in a democracy, in a liberal democracy, all decisions by the governments must be backed up by a clear stated law. So usually there is a formal procedure according to which a government can make a decision, and the decision should be backed by a specific law, and this law must be published for those decisions to have a direct an immediate effect. Now, on that day, Boris Johnson went on television and he basically claimed, you must stay at home. We are imposing a lockdown, and this is, of course, for the safety of the nation. He spoke about an invisible threat, an invisible enemy. Of course, it was a virus. Viruses cannot be, they're not visible. And he claimed that the police will have the authority to enforce this lockdown. But the law supporting and giving legitimacy to this decision was not published yet. So and the interesting thing is that the law supporting Boris Johnson's decision has been published 3 days after. Now, the question is, what is the effect of Boris Johnson's decision, of Boris Johnson, in a sense, performative act of going on television and telling us to stay at home? Of course, when I heard about the lockdown, I was in my room and I stayed at home. I didn't go out. I followed his advice, his decision. But the question is that decision was not supported by the law. So for 3 days, we have been under a lockdown, and this lockdown was not supported by a clear law imposing a clear law formally decreeing the lockdown. And this is Adam Wagner, is a human rights lawyer, quite a popular one in the United Kingdom, wrote a book, a very interesting book, and also an easy one, on the experience of the legal problems of the legal issues involved in the implementation of lockdowns in the United Kingdom during the coronavirus pandemic. And he wrote that Where was the law? I asked the question on Twitter and was given various answers. It could come through the Civil Contingency Act, 2004, an act of parliament designed to grant sweeping powers in times of emergency, defined as an event or a situation which threatens serious damage to human welfare or to the environment of a place, or war or terrorism threatening serious damage to security of the United Kingdom. Perhaps the rules would be in the coronavirus bill, a vast collection of powers and rules which was being rushed through Parliament at breakneck speed, even as the Prime Minister stood up to address the nation. Which law would be used to remove our freedoms? The answer was that the law did not yet exist when Boris Johnson made that statement. And it would not appear until 3 days later, posted on a government website at around 3 p.m. on Thursday, 26th March. And this is again Adam Wagner. Since the lockdown law restricted our rights more than any other in history, you might have expected such a bonfire of liberties to be fiercely debated in Parliament before becoming law. But it was not debated at all. Using an emergency procedure, the law came into force the moment it was signed by the Health Secretary, Matt Hancock. Hancock utilized what turned out to be almost unimaginably vast powers under the Public Health Control of Disease Act 1984, which was an act that has been passed by the Parliament in the 80s to fight the AIDS epidemic. Now, you see here the problem of emergency. In emergency, timing is really important. Emergencies are, in an emergency, we are in a state of urgency. So we need to act. Quickly. And at times, governments feel compelled to act also against the law to protect the social and political body of a nation. But in this case, in this specific case, Boris Johnson acted, and the lockdown has been imposed on a legal void, on a legal vacuum. And of course, this is quite problematic in terms of democratic values, and especially the values of a liberal democracy, for which legal regulation, legal color is very important, and all deprivation of rights must be justified and must be formally imposed through the use of the law. And I stop here. Thank you. I hope you enjoyed this presentation. And before leaving the floor to Tom, I invite you, if you have questions, to write them in the chat.
Myself, so you can hear me. I will share these slides. Joe and Giacomo will monitor the chat. Again, if any of you have any questions or comments. I feel I should admit at this point that in 2020, I was a civil servant and I did work on the Coronavirus Act, preparing it for Parliament. In the United Kingdom, I'm a public lawyer, so I'm a constitutional lawyer. So I teach public law here at Kent. And in the United Kingdom, we don't have a codified constitution. We're one of the very few countries not to do so. What we do have is a principle called parliamentary sovereignty. And that principle effectively says that whatever Parliament does is legal. So if Parliament wants to pass a bill like the Coronavirus Act, if Parliament wants to give the Health Secretary huge amounts of powers, they can do so. Other examples that we can look at when we get to hopefully teaching you here at Kent. Parliament has passed a law relatively recently to give undercover agents complete immunity from criminal prosecution and also civil liability. So if someone is hurt, harmed by an undercover agent, a police agent, a tax agent, a disability, someone working for the DWP, undercover agents trying to root out benefits cheats, and someone is hurt or that agent steals from you, they have complete immunity. Another thing to note, if you are a British citizen, Parliament has passed a law to allow your citizenship to be removed without you being notified. So if you are in the same position as me and you have parents or grandparents who are not British or were not British, you are at risk of having your citizenship being removed without being told. And the first time you may find out is when you're going through the airport with your passport and it doesn't work, or trying to re-enter the country and discovering you're no longer welcome here. So in the United Kingdom, we have an uncodified structure or constitution, and that has led to abuses. It's led to abuses recently in terms of the Coronavirus Act. What I'm going to look at is a historical abuse. This is known as the Kenyan Emergency. Kenya was a British colony, and this happened in the 1950s. It was emergency powers given to the British colonial officials that were quite egregiously, hugely abused. So this little flag here is the flag of British Kenya. Now I want to start off, let's talk about legal issues. Under the law at the time, in the 1950s, you were British if you were born in the British Empire. So that doesn't matter, it didn't matter if you were born in Kingston, London or Kingston, Jamaica. If you were born in the British Empire, you were considered British. British subjecthood, citizenship, flowed from what is called allegiance to the crown. If you were born in British territory and you had no other nationality, you were British and you owed your loyalty to the king and country. A natural born British subject was any person born within His Majesty's dominions and allegiance, bits of the earth Britain owned. And also, if your father was a British subject, you were also a British subject as well. But this is from an act from 1914. The final bullet point is the important one for my purposes. Parliament allowed colonial authorities to treat different classes of British subjects differently. So Parliament did allow British subjects to be, certain British subjects to be discriminated against. Okay, so this is a map of Kenya from 1901. You will see it's in grayscale. Effectively, when Britain colonized Kenya, the valuable farming land was taken for white settlers. There were about 30,000 white settlers in a colony of 5 million. So the Kenyan people, if you were effectively labeled Black African, you were banned from the best farmland, and the land became known as the White Highlands. So British Kenya was, at this point, a deeply unequal society. It was a deeply discriminatory society. Although both white Kenyans and black Kenyans were both British, black Kenyans were hugely discriminated against in a number of different ways. They weren't allowed to vote. They weren't allowed to be tried by a jury. They weren't allowed to serve on a jury. As a result of this discrimination, independence movements began. And one of the main independence movements that was armed, it was armed and it did kill people and hurt people, was known as Mau Mau. And this basically started an independence movement. The Mau Mau independence movement started in the early 1950s. And the colonial British authorities viewed this as a threat to British rule. As a result, they declared an emergency, and that emergency allowed the colonial authorities to do whatever was necessary to defeat the insurgency, to defeat Mau Mau. Just keep that in mind. We have a law passed that gives the Kenyan colonial government power to do whatever is necessary to defeat the emergency. As you've said, as I said here, they placed restrictions on land ownership, a specific impact on the Kikuyu people. The Kikuyu are the largest ethnic group in Kenya. Today, they're around 17% of the total population. And the Mau Mau, the independence movement, received their support from the Kikuyu people. Now, this was not a normal war. This was a guerrilla war. The Mau Mau didn't fight pitched battles. They would undertake guerrilla tactics, hitting police stations, targeting soldiers, targeting wealthy white landowners. And obviously they wouldn't wear a uniform. So it was very difficult. The British found it very difficult to distinguish the Mau Mau fighters from, say, the wider Kikuyu population. And again, in 1953, we have about 15,000 estimated Mau Mau fighters in Kenya, again, out of a population of about 5 million. So the British, using the emergency powers to do whatever is necessary, decided to sift through the large Kikuyu population. They would effectively try and identify, interrogate, and punish suspected Mau Mau members. They would go through the entire Kikuyu population, which was about 1.2 million at the time. They would identify the Mau Mau members. How is an open question. And they would punish those who would be definitely decided to be Mau Mau. Now, I will put just a content warning on this. I have edited a lot of the most descriptive events of what happens, but a lot of the descriptions that do happen will describe state violence, acts of torture, and also racial imagery, because the British government started a psychological warfare campaign. They used propaganda. They tried to demonize Mau Mau. This is a poster from about 1954, focused on white settlers, basically showing this kind of very aggressive figure with a gun, stating that white farmers should protect their firearms, make sure Mau Mau do not get the firearm. 65 firearms have been stolen from private individuals in the last 3 months. So we're talking about a propaganda campaign, number one. Secondly, remember, the colonial government could do whatever is necessary. So they set up a series of prison camps in order to process over 1 million Kikuyu people. They set up a series of prison camps where people would be processed, detained, questioned, and charged if necessary. And the way this was presented to the British Parliament in London was that this process, this pipeline, as it was called, would cure the Mau Mau of their disease simply through a program of hard labor and re-education. Now, that in itself may sound problematic, but the reality was much different. What was the reality? The reality was mass arrests, number one. The entire Kikuyu population was under suspicion of being Mau Mau supporters, so entire villages were arrested and led away for questioning. Here's one picture from 1952. This is part of the propaganda campaign. This is the official title from the UK State Archives of this picture. British soldiers assisting police searching for Mau Mau members in 1954. Effectively, again, we have every man they could find crouched down on the ground with the hands in the air, with soldiers with automatic rifles pointing at them. This is not a precise screening operation. What this meant was, over the course of the emergency from, say, 1952 to around 1959, 1960, hundreds of thousands of men, women, and children were imprisoned in prison camps, often in appalling conditions. If you house people very closely together and you do not give them sufficient water, or you do not have a sufficient plumbing system to get rid of human waste, disease will run rampant, and disease ran rampant. Even for those Kikuyu people who were not formally detained, 1 million These are all British subjects, right? 1 million were forcibly removed from their homes and resettled in villages. These villages were surrounded by soldiers and barbed wire. They could be controlled. This is how the British emergency rule decided to get rid of Malta, effectively imprisoning an entire population of British citizens. Here's a camp. As you can see probably one house or hut in the background on the left. You are looking at hundreds of people sitting out in the baking sun, surrounded by barbed wire and soldiers. This is not sanitary. These are not sanitary conditions. Remember again, the emergency law at the time gave the colonial officials the right to do whatever was necessary to end the Mau Mau threat. This is an interview from a Kenyan woman, Christina Wambiu. It's found in the UK National Archives. She explains what happens. So Home Guards plus army soldiers would come to our village early at 6 a.m. You would hear the doors being hit thus. That's the sound of the doors being hit. Open the doors. They said, open up, open the doors. Once they got in, they were straight to beating you. They would beat us and take some to the guard post in critical condition. Once there, she would be beaten further until she was completely dead. British emergency law at the time gave the colonial authorities power to do whatever was necessary to end the threat. It includes physical violence, it includes prison camps, it includes what we would call now unlawful killing or murder. Here is an example of a British prison camp in Kenya in the 1950s. For those of you who've studied World War II history, it looks very similar to prison camps or concentration camps you would find in Germany or Poland in World War II. That's because it was. So effectively, prison camps are concentration camps. They are guarded, they are surrounded by barbed wire, people are kept there, they are not allowed to leave. Here's another example. Armed soldiers with bayonets on the other side of the barbed wire. If anyone tried to escape, they would be shot. Caroline Elkins is a historian from the United States who's done a huge amount of research on the Kenyan emergency. If you are able to access her book, Legacy of Violence, I would strongly recommend it for you. It is an excellent, excellent book. Very uncomfortable book reading about British history, but a very, very excellent one. She explained that both white and black agents of empire, so by this she means white British settlers and also black Kenyan soldiers, policemen, perpetrated horrific crimes in defense of British rule in Kenya. They used electric shock and hooked suspects up to car batteries. They tied suspects to vehicle bumpers with just enough rope to drag them to death. They employed burning cigarettes, fire, and hot coals. They crushed bone and teeth, sliced off fingers or their tips. Some used a kiboko or a rhino whip for beating. Others used clubs, fists, and truncheons. Bucket fatigue was a routine practice, as were various forms of human excrement torture. Mau Mau suspects and detainees were forced to clean night soil buckets barehanded. Night soil buckets is basically where you go to the toilet in, and run for hours around a compound holding a full night soil bucket aloft, which then spilled over, encrusting the person holding it with feces and urine. No Kikuyu, man, woman, or child was safe. And I will remind you again, these are all British subjects, right? Born in British territory, they are British. Caroline Elkins published this in the first decade of the 21st century, her original research. And at first, the British government denied any of this happened. Absolutely. There we go. They denied it happened until around 10 years ago, they admitted that it did. The British government admitted that they had conducted what they called Operation Legacy. Operation Legacy was a colonial office program, it's now the Foreign Office, to destroy or hide files to prevent them being inherited by ex-colonies. From the 1950s to the 1970s, the British government destroyed or hid all the evidence of colonial abuses of powers in emergencies after World War II. So MI5 or police agents would vet all secret documents. They would find any documents, say, admitting the existence of prison camps. They would say all documents to admit the existence of a torture program, and they would keep them or destroy them. They would not allow them to fall into the hands of the independent government, say, of Kenya. They would not allow any evidence to exist. And precise instructions were given for the destruction of evidence, including the burning and dumping at sea of large amounts of documents. In terms of Kenya, we know the government admitted they destroyed 3.5 tons of paperwork relating to the Kenyan emergency. 3.5 tons. I'm sure some of you are aware how much a pad of paper weighs. That's an awful lot of paper that is being destroyed. And this also meant that when Kenyan detainees sued the British government, some of them did, who were still alive, they were very elderly, they were detained in the 1950s. When their cases reached court in the 2010s, the British courts in London did not allow the cases to continue. They didn't allow the cases to continue. The detainees lost their cases against the British government on the basis that so much time had passed between the emergency and the court case in the 2010s that the British government would no longer get a fair trial. That's despite the fact the British government had admitted that most of the evidence that should have been available to those detainees to sue them had been systematically destroyed. Right. So we will, if you come and study with us, and I hope you do, in public law, we will be looking at these examples of where the UK's constitution doesn't work or hasn't worked historically. And we'll also invite you to think about ways to improve the UK's constitutional systems, ways to ensure that people who suffered injustice in the past could receive justice now, and also ways to ensure that prime ministers can't simply pass legislation through during a pandemic without real scrutiny to give them large powers to stop your freedom of movement. Okay, I will stop there. Lovely.
Thank you, Tom. And we have two questions. So the first one, do international emergency laws like Article 15 go far enough to protect marginalized groups? Or do they make it easier for government to pass unfair laws that hurt those already disadvantaged? I think I can give my my opinion on that. I'm mainly accustomed and I read about Article 15, and to the best of my knowledge, the answer to that question is that international law is quite ineffective in protecting marginalized group, or even in a sense curtailing government's power in implementing, as you say, fair laws or even emergency laws. To the best of my knowledge, all major judgment provided by the court acknowledged that as long as there is an emergency in place, states have a wide margin of appreciation in dealing with emergencies internally. Now, here we reach one of the perhaps the I would say the core of the issue. So, what is an emergency? And the problem is that if you read the text of the law of emergency laws, you see that the language that is used is, vague on purpose, because we can't define the future, we can't foresee the future with clarity, so we can't make a list of all potential emergencies. Okay. Now, on the one hand, these, as I said, it's a double-edged sword. So emergency laws are, of course, useful, but are open to all possible misuses and abuses. Yes, but overall, I think international law. But we see the and we see the status of international law and the fact that it's overall ineffective right now. Just looking at what's going on right now in Palestine or in other in other parts of the world in which a genocide is taking place. But even where it's not a case of genocide, or because what happened in Kenya is the creation of actual concentration camps. Even when the situation is not so extreme, but there is a war going on, we see that international law is basically ineffective. But this is my modest opinion, and as you know, Tom is a public lawyer, and he will deal with these issues in his teaching. Yeah, I mean, I think we might agree on this point on the ineffectiveness of international law in general, and in the case of emergency laws of those provisions that are in a sense meant to limit the action of governments in cases of emergencies. But then we have a second question, Tom, and I think this is more for you, I would say. Shall I read it? Or you do it?
Yeah, you can hear me, okay?
Okay.
How was the British government able to legally withhold and conceal evidence of abuses against them now for decades through Operation Legacy? And what does this reveal about the limits of transparency, accountability, and the rule of law in former colonial contexts? Well, how can I put this? Kenya was not an exception, sadly. Similar emergency powers were used in Malaya, which is modern-day Malaysia. It was used in what was called the Mandate of Palestine, so which includes Israel, Palestine, and Jordan. It was included in Cyprus as well. So the issue here was the public law. There wasn't a public law challenge. The public law challenge would be, if you're challenging in public law, you ask, was the action of the authorities lawful? The question was, well, broadly speaking, yes, it was. It was lawful because they had been given incredibly broad powers to act. So it was very difficult for them to act outside of those powers. So the challenges, the legal cases that the Kenyan detainees brought against the British government were in private law. They were in things like false imprisonment, assault and battery in private law, so not the criminal law offence. And unfortunately, there is a time limit. There is a time limit to how long you have to bring certain cases in English law. So if I remember rightly, I think it's 3 or 6 years, depending on the exact case in contract and tort. So effectively, this case was being brought 55 years after. So the British government simply maintained the detainees are out of time. We can't get a fair trial. And the British courts agreed. So how were they legally able to withhold and conceal abuses of evidence? Well, they were able to hide behind what we call limitation periods. They were out, the claimants were out of time. No one could challenge the action because half a century had passed. That's a very, very technical defense. But you will discover that, especially when it comes to the British state and English law, the British state often relies on technical offences to avoid liability or avoid any kind of adverse court judgment. Now, in terms of transparency, accountability, and the rule of law in former colonial contexts, we've got to remember that the rule of law is a fundamental principle in common law legal systems. It's the idea that the law must be fair, it must be applied equally, it must operate, it must not discriminate. But in the British context, Parliament is sovereign. So Parliament can legislate what we call legislate contrary to the rule of law. If Parliament passes an unfair law, that's it. You follow the unfair law. And so not just in Kenya, but in a lot of colonial contexts and even in British contexts, Parliament has passed or approved laws which may be unfair, which may take away your rights, which may take away your liberties. And courts will always follow the words of Parliament, even if it violates the rule of law. We do not have a constitution that says Parliament must follow the rule of law, or the rule of law is this. So that is a challenge when it comes to UK constitutional thinking. It's a challenge for you, those of you who are watching, as voters. When you choose your MPs, some of you may have been old enough to vote in last year's election, but when you choose your MPs, you are giving those MPs power to make the law. You're giving those MPs power to legislate for illegal things. So there's a huge amount of power Parliament has, and that's why Giacomo's point about scrutiny is so important. We rely on Parliament to scrutinise proposed laws because of the power Parliament has. And if you are not scrutinising laws and simply passing laws without any consideration or questioning, then courts cannot intervene. And it's not the most uplifting conclusion, but that's the point. Parliamentary sovereignty means Parliament can do whatever they want, even if you don't like it, even if it feels unfair, even if it violates principles like fairness or equity or the rule of law.
Good. So I think we can end this session here. Thank you all for participation, for having joined this session. And again, I mean, these are some of the topics that you will encounter in our department, in the delivery of modules, especially in my modules and Tom's modules. And well, I hope to see you soon. And thanks again.
Thank you.
Bye.